You and the baby need to stop by probation to make an appointment. Court does call the case, People versus Albert Wilson.
Good morning, Your Honor. William Amadeo, P76194. On behalf of Mr. Wilson.
In one single courtroom session, this judge goes from mercy to absolute zero tolerance. Miss a test? Jail warning. Fail to appear? Bench warrant. Try to plead guilty without paperwork? Not happening. What you're about to see isn't chaos. It's courtroom control in real time. Bonds are on the line. Freedom is hanging by a thread. And for several defendants today, one small mistake could mean cuffs. Watch closely, because this judge is giving chances, but not second chances.
The judge says he could revoke bond right now, then gives one last warning. Miss another test, and he is going straight to jail.
Albert, please state your name for the court.
My name is Albert George Wilson.
What are we doing?
Judge, we do have an agreement in principle, but I'm going to need your consent on it if you're going to be doing a sentence agreement. We're trying to do in lieu of the 5 days in jail community service. He also has to do.
I don't do those. Never have.
Would you accept the sentence agreement from me and the people?
Will I accept? It would be the same thing, wouldn't it? Well, have you seen his bond violation?
I have. We approached briefly.
Yeah. All right. Record should reflect you had a bench conference in this case. Sir, Mr. Wilson?
Yes?
You are missing a number of tests and not testing timely. Is there a reason why that's occurring?
Well, I think I have missed, but it'll be something like maybe I overslept or I didn't completely miss any of them.
We can't do that.
Oh.
So
Pause right here. This is critical. The judge openly states that normally he would revoke bond immediately for missed tests. That's huge. Bond isn't a right, it's conditional freedom. And drug or alcohol testing compliance is often a strict requirement. Notice what happens. Instead of immediate jail, the judge gives a final warning and adjourns the matter. That's judicial discretion in action. He's balancing accountability with opportunity. But the line is clear. Between now and then, there are to be no misses. So here's the real question. Should someone who repeatedly misses required testing get another chance? Or does leniency undermine court authority? The judge just made it crystal clear. Next violation equals jail. That's not a suggestion. That's a promise.
So and you can thank your counsel for this, because normally my position, he gave me some information. Normally my position is I'd revoke your bond and remand you right now, because I don't tolerate that. You understand that, sir? What I will do is I'll adjourn this matter to February 18th, 2026, 9 a.m. Between now and then, there are to be no missed test. If you do, then it's going to be jail time for you. Understood?
Yes, sir.
Bond will continue.
Thank you, Judge.
Court calls the case, People versus Gavin Whipple.
My case is getting not Raymond Cook. People.
Conrad Siller on behalf of Pittsfield Township. Mr. Cook was a little quick.
Yeah, I think so. Mr. Speck, we cannot hear you, sir.
Still can't hear you.
What I'm going to suggest, Mr. Speck, why don't you let me pass it, sign off, and then come back in, or however you need to do it. I'll pass that case. Court does call the case, People versus John Dauphine.
Your Honor, Raymond Cook for the people.
Sure.
No. I am.
Morning, Honor Robert J. Cohen, on behalf of Mr. Goffin, approaching the podium. John, would you state your name for the record, please?
Yes, good morning, sir. John Duffy.
Flip your side.
Oh,
Oh, all right, sorry about that. Judge, today's time of day for a pretrial. Can we set this for a final settlement conference?
Both cases.
Yes, Your Honor.
No objection setting for this Friday's conference.
Any objection to that, Mr. Killaloe?
No, Your Honor.
Jury final settlement conference will be set for February 6th, 2026, 9 a.m. Jury selection, February 9th, 2026, 8:30. Both of those proceedings are in person.
Thanks, Judge.
Bond will continue. Thank you.
thank you, Your Honor.
All I get is copy. Back. Okay. Court does call the case, People versus Sharon Abbott.
Morning, Your Honor. Raymond Cook for the people.
Carolyn Foster Tucker on behalf of Sharon Abbott.
Sharon Abbott.
Thank you. You need to take your hands out of your pockets, please.
Your Honor, I have spoken to Mr. Cook. I know this case has been pending for some time, but we would be asking for one last adjournment. We do have a potential resolution. Miss Abbott has some employment concerns that she'd like to speak to a licensing attorney about to help her with that process when the time comes. So we're just asking for some time for her to do that.
I had indicated at the last hearing, it was the last adjournment.
Understood, Your Honor. Then, could we set for final settlement?
Could we get the April final settlement?
Jury final settlement conference will be set, say in 10, 13, April 10th, 2026, 9 a.m. Jury selection, April 13th, 2026, 8:30. Both of those proceedings are in person. Bond will continue.
Thank you, Your Honor.
Thank you. Cross case, People versus Austin Shepherd.
Morning, Your Honor. Raymond Cook for the people.
Carolyn Foster Tucker on behalf of Austin Shepherd.
Austin Shepherd. Thank you.
Your Honor, we're requesting a final settlement conference date.
Jury final settlement conference, April 10th, 2026, 9 a.m. Jury selection, April 13th, 2026, 8:30. Both of those proceedings are in person. Bond continue.
Thank you, Your Honor.
Thank you. You're welcome. Court calls the case, People versus Tatiana Tedder.
Morning, Your Honor. Raymond Cook for the people.
Carolyn Foster Tucker on behalf of Tatiana Tedder. Your Honor, I have spoken with her and she indicates she's on her way. I just asked to pass the matter.
From where?
She had to drop her kids off this morning. It's running a little late. I apologize.
No, you don't. I'm kidding. The court calls the case, the People versus recalls Gavin Whipple.
Conrad Siller on behalf of Pittsfield Township.
It's arraignment and pretrial.
Yeah.
Mr. Smack, we cannot hear you.
Can you hear me now?
We can hear you now, sir. Thank
Very
you.
good. Good morning, Your Honor. Alan Speck up here on behalf of the defendant, Gavin Whipple.
All right. Mr. Whipple, can you state your name, please?
My name is Gavin Whipple.
Thank you. This is an arraignment and pretrial. As to the arraignment, you waive formal reading. Your client stands mute at this time.
Yes, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea on his behalf. All right.
Your Honor, I did have an opportunity to speak with the prosecutor regarding a possible reduction of the charge. They're unwilling to do so. The court's willing. My client is willing to plead guilty as charged today.
He wants to plead guilty as charged.
Yes.
Mr. Whipple, can you raise your right hand, please, sir? Yeah, no. I need a plea form submitted, but he's pleading his charge. We'll just do it. Sir, do you solemnly swear or affirm that you'll tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
My name is Gavin Whipple.
All right. You can put your hand down. Sir, it says court's understanding that you're going to plead guilty to the charge of alcohol possession by a minor in a motor vehicle. That is a misdemeanor punishable by up to 90 days, $100 fine plus court costs, community service, and any substance abuse screening the court deems necessary. You understand that?
Yes, sir.
All right. In understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
I plead guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I understand.
Yeah, we're not going to be able to do this. Has he signed an advice of rights form, counsel?
I believe he did. Let me double check that, Your Honor.
I don't think he has because he hasn't been arraigned. I'll tell you what. No, here's what we're going to do. I'm not going to take the plea. You guys are going to have to fill out a plea form. I need an advice of rights form to make sure that he understands all of his rights as it regards this. I will adjourn this matter out to February 18th, 2026 at 9 a.m. As to bond in this case, I will set a personal recognizance, $5,000 bond. I'll order standard conditions, including no assault behavior or possession of any weapons. There's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. Mr. Siller, was an alcohol test given at all?
Yes, Your Honor. They did do a blood draw on him because this was very close to being a drunk driving. They had submitted a warrant request for drunk driving. I don't think he met the definition of operation under the law. So they did do a blood draw. It was 0.078. Unfortunately, he was in a parking lot at the Meijer store. He was going to have to drive away from there at some point. So, he came about one step away from getting a drunk driving.
Got it. I am going to order that the defendant report to the Department of Community Corrections within the next 24 hours for placement on a SoberLink testing device. You understand that, sir?
Yes, sir.
Thank you. We'll see you in a couple weeks.
Okay.
Thank you, Your Honor.
Court calls case People versus Brandon. Is it Kiriakosa?
Kiriakosa, Your Honor.
Kiriakosa.
Morning, Your Honor. Raymond Cook for the people.
Your Honor, may it please the court, James W. Murray, P48047. I represent Mr. Kiriakosa. Please state your full name.
Brandon Kiriakosa.
Thank you. What are we doing?
Your Honor, I've got some good news. We have a settlement in this matter. I have fully executed advice of rights, as well as the plea agreement signed by the prosecutor, myself, and Mr. Kiriakosa.
Plea form indicates that the defendant will be pleading to an added count 3 of disturbing the peace, the 90-day offense. Upon a successful plea to that charge, count 2, the retail fraud, will be dismissed.
Your Honor, this started as a felony. Count 1 was the felony matter that got.
Got it. Okay. Now I understand. And defendant is agreeing to pay restitution in full amount of $103.97. There's a sentence agreement to deferred sentence probation to include intervention program.
Theft intervention program.
Theft intervention program. That's the court's full understanding of the.
That's correct, Your Honor.
Is that a correct statement?
It is, Your Honor.
May I have it sworn?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name, please.
Brandon Kiriakosa.
Sir, it is this court's understanding that you're going to plead guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes.
All right. And understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty?
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Were you on probation at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty?
Yes.
On the date of January 5th, 2025, at the location of 3158 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you at the TJ Maxx store?
Yes, Your Honor.
Did you engage in behavior that created a public disturbance?
Yes.
All right. And you would agree that your conduct at that store at that time disturbed the peace and repose of the area surrounding or immediately surrounding you?
Yes, sir.
All right. Sir, if I accept your plea, you need to understand that if you commit misconduct between the time of this plea and the time of my sentencing, that the court would not be bound by any sentence agreement and or sentence agreement evaluation or recommendation, and you could not withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 3. Count 2 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be March 11, 2026, 9 a.m. On with its conditions, we'll continue.
Your Honor, thank you very much.
Thank you. Sir, on your way out, you can stop down in my probation department. They're on your left, about maybe 2/3 of the way down the hallway.
Okay, thank you.
Thank you. Court calls case People versus Aaron Williams.
Morning, Your Honor. Bring it to the people.
Morning, Your Honor. Michael Vincent on behalf of Aaron Williams.
Here?
No.
Not here.
No.
Where? Okay.
I'm here.
And where are your people?
They are.
Well, where are your people? Because they don't, you're not supposed to be traveling alone. What?
They're at 302 North Karen, trying to accommodate
okay
my desire to have my client here.
I see.
I've talked with him. I have no idea why he's not here. If the court.
And now the tone shifts completely. One defendant doesn't show. Bench warrant. Another doesn't log in. Bench warrant. Another has multiple warrants already. Bond adjusted. This is the part most people don't see. Court isn't just dramatic speeches. It's procedure. If you fail to appear, the court must respond. Otherwise, the entire system collapses. Notice how quickly the judge moves. There's no emotional reaction, just action. $5,000 bonds. 10% provisions. Warrants issued immediately. That's efficiency, but it's also a message. Show up or face consequences. Do you think courts should be more flexible with failure to appear? Or is consistency the only way to maintain order? Because today, attendance equals
If the
freedom.
court permission, perhaps to adjourn this for a week.
That's not going to happen. Bench warrant will issue bond 5,000, 10%. That warrant will issue immediately.
Thank you.
All right. Thank you. But they know you're here.
With orders.
Okay. All right.
Been out in the hallway.
Okay. I just want. He's out wandering alone. Court calls the case People versus Alexis Alexander.
Morning, Your Honor. Raymond Joseph.
I'm appearing on behalf of Miss Alexander. Your Honor.
Yeah, where she is?
I was hoping she's on Zoom. She doesn't answer.
She is not on Zoom. Alexis Alexander, bench warrant will issue for defendant's failure to appear once again. Bond will be set in the amount of $5,000. 10%, that warrant will issue immediately. Court calls the case of the people versus Byron Blair.
Morning, Your Honor. Raymond Joseph.
Rob Brown appearing on behalf of Byron Blair, Your Honor.
He's in Zoom. All right, what are we doing? Mr. Blair, can you state your name, please? Do you hear me? Now we can hear you. State your name.
My name is Byron Blair.
Thank you. What are we doing?
Your Honor, I'm requesting an adjournment in this case.
During the matter of February 18th, 2026, 9 a.m. Bond continued.
Thank you. Thank you.
All right, thank you.
How it looks.
That's okay. All right. All right. Thank you. Court calls the case of the people versus Ryan Brown.
Order Judge Torshall Feast, the first assistant public defender on behalf of Mr. Brown, who should be hopefully on Zoom.
Ryan Brown, you see his name at least.
Okay.
Yes,
State your name.
Ryan Brown.
Thank you, Judge. I did speak to Mr. Brown yesterday and this morning. A plea offer has been tendered to Mr. Brown. He'd like us to adjourn this matter briefly to have some more time to talk about the
February 18th, 2026, 9 a.m. on both matters. I would indicate also only one is on.
Yeah, 6.
The other, he also has a warrant on another case, a driver while license suspended or unlicensed.
Okay.
In that case, number is 124-0610.
Okay. I will have him turn us over on that.
He needs to deal with that. He also has a companion case, another warrant out of 1482. That case number being 232-0744.
And that's a bench warrant also?
It is a bench warrant also. Yes.
Thank you, Judge.
Thank you.
Excuse me, though.
I'll be in touch soon, Mr. Brown.
Thank you. Same thing. Court calls the cases of the people versus Christopher Chambers.
Morning, Your Honor. People.
Show cause without on both cases. Not here. This is show cause on these cases. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000, 10% on each case. Those bench warrants will issue immediately. The court does call the case of the people versus Carlton Cross.
People.
Order Judge Torshall Feast, the assistant public defender on behalf of Mr. Carlton Cross, who I hope is on Zoom.
Or sorry about that. Just put it in the back. That's okay.
Unbutton it.
Yeah. Sorry about that. Sorry, Judge. I'm trying to.
Yeah, I can tell you're not accustomed to wearing a tie either. So.
No, well, I actually don't even like ties. Or
Yeah,
ties.
no, I got you.
I've been trying that. is it, can you see it?
Just to the side.
You don't mind?
No, sir.
You want to straighten his tie too? No, that's okay.
I just want to be presentable.
I appreciate the effort.
All right. Torshell Fuster, Assistant Public Defender on behalf of Mr. Cross. Mr. Cross, please state your name for the record.
Carlton Dion Cross.
Thank you, sir.
Thank you, Judge. I did speak to the prosecutor on this case. Sounds like a global is in the works here that might involve sobriety court. If we could have an adjournment for 3 or 4 weeks, we can see what we stand.
It's my first date, March 4th. I'll adjourn the matter March 4th, 2026, 9 a.m. And you're looking to get it into a sobriety court.
That is the global offer.
Okay. All right. Bond will continue. Thank you, sir.
Have a good day.
We'll be in touch.
Courthouse case, people versus Comaria Davis.
Morning, Your Honor. Raymond Cook, people.
What is that? Torshell Fuster, Assistant Public Defender on behalf of Ms. Davis, who is approaching the podium. Please state your name when you get to the podium.
Right up here.
Thank you, Judge. I have my client, and I have read the notes in the file. It looks like we are requesting a brief adjournment. There are some videos in this file that Ms. Davis wants to watch before she determines how she wants to proceed, and she will be watching those this morning after court.
February 18th, 2026, 9 a.m. Bond continue.
Thank you, Judge.
Yeah. Court calls the case, people versus Rick Artuso.
Morning, Your Honor. Raymond Cook, people.
What do you mean he's not here? Mr. Artuso here? FMR counsel. And you haven't heard from Mr. Bridges? Bench warrant will issue for defendant's failure to appear, bond 5,000. Give a 10% privilege on that. That warrant will issue immediately. Court calls the case of people versus Ricky Burdett.
Morning, Your Honor. Raymond Cook, people.
You not have consequences.
Where's his attorney? Good morning, sir.
Good morning, Your
What's
Honor.
your name?
Ricky Burdett.
Do you know where your attorney is?
I do not. We'd agreed to meet at this time. I do not know where my attorney is. So I'm speaking for myself, I guess.
Well, no, you're not, because they filed a substitution of attorney, which I signed off on, saying that they were going to represent you. So you're going to be represented by counsel. Do you have a phone number for him at all, sir?
I do. It's
all right.
I may have it here. My phone is in my vehicle.
Oh, okay, I got you. So we're going to give a call to his office, find out where he is. So you can have a seat. I'll pass the matter. Okay, I'll call it up in my next block.
Do you mean wait on him to come?
Yes.
What if he does not show like today?
Pardon?
What if he does not show today? Like for hours, you know?
I don't know. I mean,
it was agreed. That was his.
Okay.
That's his responsibility.
Sir, what do you want me to, what do you want me to do? I can't.
I want you to let me speak for myself then.
He has filed an appearance on your behalf. He is supposed to be here. Have a seat. We will contact him to find out why he's not here. Thank you.
You have the.
Thank you.
In minutes, the court shifts from mercy to consequences. Cases reset, bonds set, and then bench warrants start getting issued back to back.
No. The other lucky person is recall the case, people versus Tatiana Tedder. Is she here?
Good morning, Your Honor. Raymond Cook for the people.
Carolyn Foster Tucker on behalf of Tatiana Tedder.
Your name?
Tatiana Tedder.
Okay. I had faith that you'd show up.
Yeah.
You're well, bring the baby with you. For goodness sakes. Of course gonna cry. When Alan leaves me, I cry.
Okay, sorry about that. Just relax.
See? Why are you shaking your head?
Because he's just giving me a rough day today, so yeah.
That sweet little child.
Yes.
I know it's not your fault. All right. I have before me a plea form. She's going to plead to the charge of retail fraud, second degree. Correct?
Correct.
There is also a sentence recommendation or a sentence agreement of the prosecutor's deferred.
That's correct, Your Honor.
That is correct.
All right. Just, what is she?
I'm sorry.
Take a deep breath. The baby's doing nothing.
Yeah, he's just heavy.
He's just heavy?
Yeah, he's heavy.
Okay. She can sit down if she wants.
No, it's okay. He's gonna cry. It's okay. Thank you, though. No, it's okay.
You sure?
Yeah, I'm
Then
positive.
quit complaining.
Okay.
No, I'm kidding. Can you raise your right hand, please?
Yeah.
Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name, please.
Tatiana Tedder.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud, second degree.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
You understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
June 11, 2025, at the location of 31458 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What'd you do at TJ Maxx that makes you think that you're guilty?
I took some items. Just speak for me, right? Okay. I took some items. I was with another person, but I guess
You were part of
yeah.
the plan to take some items and try to remove them from the store without paying for them?
Correct.
All right. The store was open to the public at the time?
Correct.
You didn't have anybody's permission to take that property, did you?
No.
And the property that you took was offered for sale by TJ Maxx?
Correct.
And are we doing this on the price?
Yes, Your Honor.
Was the amount that you took from the store, the total amount, was that in excess of $200?
Yeah.
Your Honor, if I can voir dire her.
Go ahead.
You and your friend both took some items, correct?
Yeah.
And the amount that
Came together. Yeah.
total between the two of you was over 200, right?
Correct.
All right.
By the end of this session, we've seen the full spectrum of courtroom justice. A defendant narrowly avoids jail with a final warning. Multiple bench warrants are issued for those who didn't show. One plea rejected due to missing rights paperwork. Another accepted after careful advisement and sworn admissions. And that's the key takeaway. Court isn't about emotion, it's about procedure. Every plea must be voluntary. Every right must be explained. Every bond violation has consequences. Even in lighter moments, like a baby crying during a plea, the legal framework never changes. The judge maintained balance, firm when necessary, patient when appropriate, procedural at every step. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Ma'am, I have to advise you that if I accept your plea, if you're between the time of the plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, I do.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be March 11th, 2026, 9 a.m. Bond with its conditions will continue. Ma'am, on your way out on the left-hand side, you and the baby need to stop by probation to make an appointment.
Okay, thank you.
All right?
Yeah, thank you very much.
And be nice to that little, how old?
He's one.
He's one.
better
He's
be
just,
nice to me.
he's just one.
Yeah. Thank you.
Not that heavy. Bye. So we. Yeah.